India Legal presents Courts Roundup.
In a major verdict, the Supreme Court has set a benchmark for maintenance to be paid by a husband to his estranged wife. The Apex Court judgment dealt with criteria for payment of interim maintenance and the issue of overlapping jurisdiction of different courts.
The Supreme Court has laid down guidelines for determining the quantum of interim compensation to be paid in matrimonial cases. A bench of Justices Indu Malhotra and R. Subhash Reddy also laid down directions to be followed by family courts, district courts and magistrate courts across the country to address the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings in the same matter. The judgment was pronounced in a matrimonial case from Maharashtra in which the question of maintenance of a wife and son under Section 125 of the Code of Criminal Procedure had come to the fore. The court had on September 1 last year appointed senior advocates Gopal, Sankar Narayanan and Anita Chennai as amicus curiae to assist in framing guidelines on payment of interim maintenance. The judgment dealt with the following aspects. Payment of interim maintenance. The court ruled that an affidavit of disclosure of assets and liabilities annexed to the judgment should be filed by both parties in all maintenance proceedings, including pending proceedings before the concerned family courts, district courts or magistrate courts throughout the country. Criteria for determining quantum of maintenance. For determining the quantum of maintenance payable to an applicant, the concerned court shall consider the criteria enumerated in the judgment. The court made it clear that the said factors laid down by it are not exhaustive and that judicial discretion is vested in the family courts to consider any other factor which may arise in the facts and circumstances of the case. Overlapping jurisdiction. The court said that it has become necessary to issue directions to overcome the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings. Such directions are necessary so that there is uniformity in the practices followed by family courts, district courts and magistrate courts throughout the country. The following direction were issued by the courts toward that end. Where successive claims for maintenance are made under different statutes, the court would consider adjustment or set-off of the amount awarded in a previous proceedings while determining whether any further amount is to be awarded in the subsequent proceedings. It is mandatory for the applicant to disclose during the subsequent proceedings details of the previous proceedings and the orders passed in such previous proceedings. If the order passed in the previous proceedings require any modification or variation, the party would be required to move the concerned court in the same proceeding. The court ruled that an order of maintenance may be enforced, executed under Section 28A of the Hindu Marriage Act, Section 26 of the Domestic Violence Act or Section 128 of Criminal Procedure Code. Further, an order for maintenance may be enforced as money decree under the Code of Civil Procedure. Bureau Report.
And while hearing a plea to stop the commercial coal mining process in Jharkhand, the Supreme Court asserted its only primarily consideration was to see that the environment is not adversely impacted. The bench of Chief Justice of India S. A. Bobde and Justices A. S. Bhopana and V. Subramaniam was hearing a plea filed by Jharkhand government. The court sought to know whether any party would lead evidence or cross-examine witnesses. When the parties answered in the negative, the court decided to list the case for hearing. The bench was keen to understand what impact the project would have on eco-sensitive zones. It thus considered appointing an expert committee to submit a report analyzing the environmental impact the project will have. CJI Bobde observed the whole issue of looking at forest is wrong. We don't want to stop the development of the country but will not lead to erosion of the natural resources. You attach economic value to timber but not the forest. The distance of 70, 79 or 20 kilometers is dangerously close, isn't it? By way of background, shortly after Prime Minister Narendra Modi started the process of auctioning coal blocks for commercial mining, the government of Jharkhand had moved the Supreme Court to postpone the auction. The plea challenging the process of commercial mining states that there is a need for fair assessment of the social and economical impact of commercial mining on the huge tribal population and vast tracts of forest lands of the state and its residents, which are likely to be adversely affected. While disposing of the plea seeking safety precautions for students appearing in charter accountant exams, the Supreme Court observed that students appearing in professional exams should not ask for concession. The bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna disposed of the matter. The Institute of Chartered Accountants of India submitted before the court that it had a discussion with the counsel of the petitioner. ICAI stated that the institute will not be able to provide for isolation rooms at test centers as the CA exams were different from the National Eligibility Cum Entrance Test. Appearing for ICAI, Senior Advocate Ramji Srinivasan submitted, "We are strictly in accordance with the MHA guidelines. They needed isolation rooms, but we can't put to risk 5 lakh students by having such rooms as this exam is for 18 days. We can't risk this with COVID patient coming in." Addressing the petitioner, the court said, "How can this be allowed? Just because courts are allowing this, you cannot keep on asking what you want. Be reasonable in your demands." The court then said to Advocate Bansuri Swaraj, appearing for petitioner, that it was not impressed by their submission. ICAI has now been directed to publish a press release on its website answering all the grievances of the petitioner in detail so that the students are aware of all the facilities being provided for the CA exams. The Supreme Court has held that the supersession of Tamil Nadu Wakf Board was illegal. The bench comprising Justices Ashok Bhushan, R. Subhas Reddy and M.R. Shah upheld the Madras High Court, which had held, and thus while dismissing the appeals filed by the state. The government had passed the supersession order on the ground that there are only 10 members in the board at the relevant time after members of parliament demitted office, and that the number of nominated members being more than the elected members, the state had no option except to supersede the board. It was stated that the senior advocate can only be considered as nominated members. Therefore, the elected members are less than the nominated members and the board is unable to perform its functions as per Wakf Act 1995. The supersession order stated. This order was challenged before the High Court, and though the single bench dismissed the writ petition, the division bench allowed the writ appeal and held that the supersession order was not sustainable. The obligation on the state government to constitute the board in accordance with Section 14, keeping in view the objective under Section 14(4), was both right and duty of the state, and any lapses therein cannot be a ground for superseding the board. The court also noted that second proviso to Section 99 contained an injunction that the power of the state government shall not be exercised unless there is a prima facie evidence of financial irregularity, misconduct or violation of the provisions of the Act. The present is not a case of any allegation of any financial irregularity or misconduct on the part of the board, the bench noted. We are now joined by Advocate Divyanshi for more update on this.
Yes. In this case, Supreme Court has held that Tamil Nadu Wakf Board was illegal and dismissed the appeal filed by the state. the court has noted that second proviso of Section 99 of the Wakf Act contains an injunction that the power of the state government shall not be exercised unless there is prima facie evidence of financial irregularity, misconduct or violation of the provisions of the Act. But in the present case, there is no allegation of any financial irregularity or misconduct on the part of the board.
Thank you, Devanshi, for the update. In the Yes Bank money laundering case, Bombay High Court has rejected bail pleas of DHFL promoters Dheeraj and Kapil Wadhawan in CBI case. The Wadhawan brothers are accused of diverting nearly 4,122 crore rupees from the General Provident Fund and Central Provident Fund deposit of UP Power Corporation Limited to their company. They have been also accused of fraudulently diverting nearly 12,700 crore rupees from DHFL's account to companies beneficially owned by them and further diverting those funds to other firms.
The Bombay High Court has rejected bail pleas of former DHLF promoters Kapil and Dheeraj Wadhawan, accused in Yes Bank money laundering case. A senior judge bench of Justice Sarang V. Kotwal passed orders on pleas made by Wadhawan brothers. On March 7, the CBI had registered a case against Kapil and Dheeraj Wadhawan along with Rana Kapoor, the then managing director and chief executive officer of Yes Bank, and others in connection with an alleged multi-crore scam connected to Yes Bank. The CBI took custody of Wadhawan brothers from Satara, Maharashtra in April this year. The CBI claimed that both Kapil and Dheeraj were on the run since the beginning of the investigation. On March 9, the CBI raided the premises of the accused, but their whereabouts remained unknown. The CBI had then issued them a notice which went ignored. The same month, a non-bailable arrest warrant was issued. The Enforcement Directorate is also investigating allegations of money laundering in the Yes Bank case. Representing Kapil Wadhawan, senior advocate Amit Desai had submitted before the High Court that CBI had not complied with the procedure under Section 173 of Criminal Procedure Code, which lays down procedure for reports of police officers on completion of investigation, while submitting the investigation report to the special magistrate. He argued that if the report is not complete, the court could not take cognizance and consequently the provisions could not be considered. Senior counsel Abhishek Manu Singhvi, appearing for Dheeraj Wadhawan, has submitted that statutory bail was a vital liberty and an indefeasible right. Singhvi said that the charge sheet filed did not provide sufficient evidence to prove all alleged offences. Additional Solicitor General Anil Singh, representing CBI, opposed the pleas, stating that all procedures and compliances were followed as per law by the CBI officials. Earlier on August 20, observing that undue delay is not conducive to administration of criminal justice, a single judge bench of Justice Bharti H. Dangle of High Court had granted bail by default to DHLF promoter Dheeraj and Kapil Wadhawan, accused in Yes Bank money laundering case, as the Enforcement Directorate could not file a prosecution complaint or charge sheet within stipulated 60 days of their arrest. Bureau Report.
And producer Nilesh Navlakha, who is one of the petitioner in the batch of PILs before Bombay High Court against media trial in Sushant Singh Rajput case, has filed an interim application seeking direction to broadcasters to disclose the source from where the WhatsApp chat, statements of accused witnesses, questionnaires of investigating agencies, etc. were received by them. The applicant has cited various instances when news channels like Republic TV, Times Now and ABP News broadcasted and that they had access to some internal documents including witnesses' statements made to the investigative agencies, also other vital information that could have only been available with the investigating agencies like CBI, ED and NCB. Selective leaks by investigating officers or agencies deflect public opinion and amounts to conduct of a trial by media by leaking selective evidence. It is submitted that the use of electronic media by the investigating agency probably to influence public opinion during the pendency of an investigation subverts the fairness of the investigation. Applicants have also sought directions for a judicial court-monitored inquiry to be conducted into the misconduct if any of the officials of investigating agencies, that is CBI, NCB or ED, or by the accused or the witnesses, and to take strict action against the concerned officers. Moreover, the applicants have prayed for direction to the investigating agencies to take necessary action against the broadcasters under the appropriate provisions of law and to file status report before the High Court. And the Madras High Court has issued notice to Indian cricket team captain Virat Kohli, president of Board of Control for Cricket in India, Sourav Ganguly, and the central and the state governments in a plea against online games in Tamil Nadu. Notice was issued by a Madurai bench of the High Court comprising of Justice N. Kirubakaran and P. Pugelendi in a public interest litigation petition filed by advocate Mohammad Razvi. Beside Kohli and Ganguly, the petition has Telecom Regulatory Authority of India and celebrity endorsers such as actor Prakash Raj, Tamanna Bhatia, Rana Dagupati and Sudeep as respondents. In his petition filed through advocate K. Neelam Mengam, N. Teju and Dheeraj Mahesh Razvi has submitted the online games promote cyberbullying, violence and xenophobia. Concerns are also raised about gaming addiction and social stigma. People may also get swindled out of their money in the name of gaming, he adds. The lockdown brings the spotlight on online gaming addiction, and the petitioner further notes, Razvi goes on to cite instances of children who have died by suicide on account of playing online games similar to Blue Whale Challenge and after losing in PUBG. And online games exposes children to a world of crime and negative thinking, he contends. Other instances where people have died because they have lost money while playing online rummy. And online gambling has also been highlighted. In this backdrop, Razvi has registered objection to celebrities who have been promoting and endorsing unethical, immoral online gambling through advertisement. His petition calls for the court to direct action against the Online Rummy Federation of India as well as the named celebrities for their role in promoting such online games. While issuing notice in the case, the bench reportedly also voiced concern that lives have been lost due to online games and that there is no law governing the same as of yet in Tamil Nadu. The Allahabad High Court has called upon the investigating officers and the circle officer attached with police station Akhand Nagar district Sultanpur to explain how the charge sheet under section 34 and 120B IPC was filed. The bench of Justice Dinesh Kumar Singh ordered both the officers to remain present before the court on the next date of listing to furnish their explanation in writing as on personal affidavits. Significantly, the court was pursuing the charge sheet which was filed against the accused applicant under section 34 relating to police station Akhand Nagar district Sultanpur, which was initially lodged under section 307 IPC, but after death of the victim section 302 IPC has been added. The court opined neither the offences under section 34 IPC nor section 120B IPC are the independent offences. These are the offences to be read in the substantive offences, and it is very strange that the charge sheet has been filed only under section 34 and 120B of IPC. How the charge sheet under section 34 and 120B IPC can be filed without adding the substantive offences. In view of the above, the court said that it was required that the investigating officer who has investigated the offence and the circle officer who would have pursued the same shall remain present before this court on the next date of listing. It may be noted that the apex court ruling in Gurudutt Mal versus State of UP makes it amply clear that Section 34 of the Indian Penal Code does not create a distinct offence. It only lays down the principle of joint criminal liability. And that's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.